Welcome everyone. This is Amer from U Counsel. There's a term that is often used in court cases and civil cases. It's called lawyer of record. What does this term mean? What are its implications? What is it that you need to know? We'll discuss that today. Before we begin, we have the disclaimer that this course is not legal advice. So for any specific questions, please contact your lawyer or paralegal or contact your law society. Lawyer of record, what does it mean? We'll define that term, we'll explain it. How do you appoint, how do you remove a lawyer of record, and what are some of the consequences if there is a removal order issued for the removal of a lawyer of record. We'll talk about that. So let's begin with the meaning of lawyer of record. So lawyer of record is essentially a lawyer whose name appears in all of the court documents on behalf of a client. And this happens usually when someone commences a court action and they go and hire a lawyer, and that lawyer drafts documents and submits it in the court system and serves it on other parties. And in those documents, that lawyer, if he is retained to represent you as a party for the entire matter, he or she will put his or her name as the lawyer of record. And so every court document will show that that specific lawyer represents that specific party, and if there are any notices, any documents that need to be served or sent to that party, they are directed towards that lawyer. So essentially, it's a lawyer for the purposes of that court action. He or she is the lawyer of a specific party, and that's what the court records indicate. How do you appoint and remove a lawyer? We'll talk about that. So there are three simple ways of appointment or removal. So if you already have a lawyer and he or she is your lawyer of record, and when you appoint another lawyer, then that's one way of removing that lawyer and appointing the other one. And there is a specific mechanism specified in the rules of civil procedure. The new lawyer has to serve what's called a notice of change of lawyers on the previous lawyer, on all of the parties or their lawyers, and then file it with the court, and that announces and puts in court records that there is a new lawyer who's appointed. There is another method of changing or removing the lawyer, and it's called notice of intention to act in person. So let's say you're a party and you were represented by a lawyer. He or she is the lawyer of record, and then at some point you decide that you no longer require that lawyer's services and you wish to represent yourself. Then in that case, there is a specific notice. It's called notice of intention to act in person. You serve that notice on the lawyer, the previous lawyer, and all of the lawyers on the other parties, and then you file it with the court, and that ensures that you have the capacity or ability or permission to represent yourself. Now, in case of corporation, as you may know, we have another lecture on this, but just to briefly tell you that corporation cannot represent itself unless it has the permission of the court. So the third category where a lawyer can be appointed or removed is if the corporation removes its lawyer and then seeks the permission of the court to say that the corporation intends to represent itself, and the court grants that permission, then that's the third mechanism by which the lawyer is appointed or removed. And the fourth mechanism, there's another one which is by way of court order. So the first three are sort of by understanding, by mutual agreement. The last one, through court order, is usually when there is some sort of a conflict and the party is unwilling or is not reasonably agreeing for the lawyer to remove himself or herself, then there is a motion that needs to be brought in court for that specific order, and the court issues an order which basically says that that specific lawyer will no longer be lawyer of record for a party. So that's the fourth scenario in which the lawyer could be removed. Just so you know, the fourth scenario, as a way of example, arises in some cases when the lawyer and the party have a sort of a breakdown of relationship, either because of their understanding of how the case needs to proceed, or the party may have lost confidence in its lawyer, or the party may not have paid legal fees for the lawyer. Some of those issues arise, and that leads to lawyer seeking an order from the court to have him or herself removed. So with respect to the lawyer's removal and appointment and all of these matters, lawyer of record, Rule 15 of the Rules of Civil Procedure of Ontario is the one that deals with that. We have discussed Rule 15 in another lecture, which was on self-representation, but this rule is specific to all kinds of representation. And 15.03, 15.04, 15.05, and 15.06, these are sort of 4 sub-rules of Rules 15 that specifically deal with the appointment of a lawyer, the removal, the intention to act in person, or a corporation's desire to represent itself. So you can have a look at that. I'll quickly show you the slide where these rules are, and then you can review them on your own later on. So one thing to keep in mind, which is important, is that once a removal order is issued, the court has issued a removal order, you have literally 30 days, and if it's the order of your lawyer, you literally have 30 days to either appoint another lawyer or serve the notice of action, intention to act in person, or in case of corporation, get the permission to self-represent. So this timeline is important. So this timeline is triggered when you have been given, or you have been served with the notice, with the order from the court that so-and-so lawyer is removed. And within 30 days, you have to either appoint another one. If you want to self-represent, then the notice for that. If you're a corporation and want to self-represent, then permission from the court to represent or hire and appoint another lawyer. So that needs to be done in 30 days. And if it's not done within 30 days, the court actually has the power to dismiss your case altogether or stay it or whatever it deems appropriate. So these timelines are important to keep in mind in case that there is a removal order for a lawyer. So these are some of the basic things that we wanted to touch upon so that you understand the purpose of lawyer of record and the circumstances of its appointment and removal. Any questions or comments, please post on our website or on the YouTube channel. And if you require any legal advice, by all means, contact us. Thank you for listening.